Picture this. You're holding your U.S. passport, that dark blue symbol of freedom and opportunity that millions around the world desperately dream of obtaining. You've worked hard for it, maybe waited years, passed all the tests, taken the oath. You feel secure, protected, untouchable. But what if I told you that under certain circumstances, that citizenship you worked so hard for, or even the citizenship you were born with, could vanish? What if I told you that right now, at this very moment, there's an entire government department dedicated to identifying citizens whose status might be revoked? What if everything you believed about the permanence of American citizenship was based on an incomplete understanding of the law? Stay with me, because what you're about to discover will fundamentally change how you view citizenship in America. Welcome back to U.S. Visa Updates, where we dive deep into the complex world of American immigration law, citizenship rights, and the policies that shape millions of lives every single day. I'm your host, and today we're tackling one of the most misunderstood and frankly shocking topics in immigration law. Can you actually lose your United States citizenship? This isn't some theoretical discussion or hypothetical scenario. We're talking about real legal mechanisms, actual cases happening right now, and government processes that have stripped away the citizenship of hundreds of people over the past several years. Whether you're a naturalized citizen, someone born on American soil, or you're on the path to citizenship right now, this information is absolutely critical for you to understand. So, here's what I need from you. Hit that subscribe button right now. Turn on notifications so you never miss an update. And if you find value in this video, share it with someone who needs to see this information. Your support keeps this channel running and helps us bring you the most accurate, up-to-date immigration content available. Now let's dive into something that could literally change your understanding of American citizenship forever. Let me start by challenging what most people believe about citizenship in this country. There's this widespread assumption, almost a cultural myth really, that once you become an American citizen, you've reached the finish line. You've made it. Your status is permanent, locked in, completely secure for the rest of your life. You have that passport, those voting rights, access to all federal benefits, and the full protection of the United States Constitution. Game over, right? You're set forever. Unfortunately, that belief, while comforting, isn't entirely accurate. The reality is significantly more complex and for some people potentially concerning. Here's the truth that doesn't get discussed nearly enough in mainstream conversations about immigration. United States citizenship, whether you acquired it through birth or through naturalization, while incredibly powerful and valuable, is not absolutely bulletproof under all circumstances. There exist legal mechanisms, established governmental processes, and documented precedent that demonstrate beyond any doubt that American citizenship can be taken away. Yes, you heard that correctly. Your citizenship can be revoked, stripped, removed. And in some cases, this can happen many years, even decades after you first became a citizen. Now, before anyone panics, let me be clear about something important. We're not talking about the government randomly deciding to take citizenship away from people they don't like. We're not discussing some dystopian scenario where rights disappear without cause or due process. What we're talking about are specific legally defined pathways through which citizenship can be lost, either through voluntary action on your part or through government action when certain criteria are met. Understanding these pathways, understanding when and how citizenship can be challenged is absolutely essential for every American citizen and for everyone hoping to become one. Let me lay out the fundamental framework we need to understand before we go deeper. When we talk about United States citizens, we're really talking about two distinct categories of people. And this distinction matters enormously when we discuss the loss of citizenship. The first category includes citizens by birth. These are individuals born on American soil, which includes all 50 states plus U.S. territories such as Puerto Rico, Guam, the U.S. Virgin Islands, and American Samoa with some specific nuances. This category also includes individuals born abroad to at least one American parent who meets certain residency requirements. The second category comprises naturalized citizens, people who were not born with American citizenship, but who immigrated to the United States, met all the legal requirements, went through the naturalization process, passed the citizenship test, and took the oath of allegiance to become Americans. Both of these groups enjoy the same fundamental rights under the Constitution. They can vote in federal elections. They hold United States passports. They have access to federal benefits and programs. They receive equal protection under the law, and they have all the rights and privileges that come with being an American citizen. On paper, there's no legal distinction between someone who was born in Kansas and someone who immigrated from Kenya and naturalized 20 years ago. Both are full American citizens with equal status. However, and this is absolutely crucial to understand when it comes to the question of losing citizenship, the government views these two groups very differently from a legal standpoint. Natural-born citizens, those who acquired citizenship through birth, are protected by the 14th Amendment to the Constitution, which establishes birthright citizenship. This protection is extraordinarily strong. The government cannot simply decide to revoke the citizenship of someone born in the United States, except in extremely rare circumstances, involving fraudulent documentation at the time of birth, which we'll discuss later. For all practical purposes, if you were born an American citizen, your citizenship is virtually untouchable unless you voluntarily choose to renounce it. Naturalized citizens, however, exist in a somewhat different legal position. Their citizenship is the result of a legal administrative process, a process that involved applications, interviews, background checks, and a formal naturalization ceremony. Because citizenship was granted through this process, the law allows for that citizenship to be legally reversed if it's discovered that the process was compromised through fraud, misrepresentation, or other illegal means. This distinction between birth citizenship and naturalized citizenship becomes critically important when we start discussing denaturalization, which is the legal term for the government's forced revocation of citizenship. Let's begin with the most straightforward way that someone can lose their American citizenship: voluntary renunciation. This is exactly what it sounds like: a formal official process through which a citizen deliberately and consciously gives up their citizenship. Now, you might be thinking, why would anyone want to give up American citizenship? We'll get to that in just a moment. But first, let me explain what this process actually involves, because it's not as simple as you might imagine. You cannot renounce your citizenship by sending an email, making a post on social media, writing a letter, or making any kind of informal declaration. The law requires a very specific formal process. First, you must physically appear in person at a United States embassy or consulate located in a foreign country. The State Department will not process renunciations on American soil. You'll meet with a consular officer who will conduct a formal interview to ensure that you understand exactly what you're doing and that you're acting voluntarily without coercion. During this interview, you'll sign an official oath of renunciation, a legal document in which you explicitly state that you fully understand the consequences of renouncing your citizenship and that you're making this choice of your own free will. There's also a substantial administrative fee involved, currently over $2,000 as of 2025, making the United States one of the most expensive countries in the world when it comes to the cost of renouncing citizenship. Here's what makes renunciation so serious and irreversible: it's permanent. There are no takebacks, no do-overs, no way to simply change your mind later. Once the State Department processes your renunciation and issues you a certificate of loss of nationality, you are no longer an American citizen. Period. The consequences are immediate and comprehensive. You lose your United States passport. You lose your right to vote in American elections. You lose access to federal benefits, including Social Security, even if you paid into the system for decades. You lose the right to live and work in the United States without authorization. If you ever want to return to America in the future, even just to visit, you'll need to apply for a visa just like any other foreign national. You're essentially starting from scratch. And there's no guaranteed path back to citizenship, even if you desperately want it later. So, who actually goes through this dramatic process? The numbers might surprise you. Thousands of Americans living overseas choose to renounce their citizenship every single year. The reasons vary significantly from person to person. Some renounce for tax-related reasons. The United States is one of only a handful of countries in the entire world that practices citizenship-based taxation rather than residence-based taxation. What this means is that if you're an American citizen, you're required to file U.S. tax returns and potentially pay U.S. taxes on your worldwide income, no matter where in the world you live. Even if you've lived in Germany for 30 years, never set foot in America during that time, earn all your income in Germany, and pay German taxes, you still have U.S. tax filing obligations. For many Americans, abroad, particularly those who have completely established their lives in other countries, this tax burden, combined with the complex reporting requirements for foreign bank accounts and assets, becomes overwhelming and expensive. Some choose renunciation as a way to simplify their financial lives. Let me share some real-world examples that demonstrate this isn't just abstract legal theory. These are actual cases that went through federal courts. In one well-documented case, a Bosnian man who had lived quietly in the United States for years had his citizenship completely revoked after investigators discovered he had participated in war crimes during the Yugoslav Civil War in the 1990s. This wasn't a minor omission or innocent mistake on his application. He had deliberately and intentionally concealed his involvement in atrocities, specifically his role in the massacre at Srejana when he applied for refugee status and later citizenship. When his past was uncovered through witness testimony and documentary evidence, the government moved swiftly. His citizenship was revoked, and he was deported to face justice. In another case that received international attention, a man who had served as a guard at a Nazi concentration camp during World War II and who had been living in the United States for more than half a century was finally identified, denaturalized, and deported. Despite the decades that had passed, despite his age and his claims that he was merely following orders as a young man, the courts determined that his concealment of his past role in crimes against humanity meant his citizenship had been fraudulently obtained. These aren't isolated incidents. They're part of a sustained legal effort that stretches back many years, with dedicated government resources focused on identifying individuals who obtained citizenship through fraud. But fraud during the application process isn't the only pathway to denaturalization. There are other less commonly known grounds that can trigger government action. One involves associations with organizations hostile to the United States. According to immigration law, if within 5 years of becoming a naturalized citizen, you join or affiliate with certain organizations, the government can initiate denaturalization proceedings. What kind of organizations are we talking about? Groups that advocate for the violent overthrow of the United States government. Organizations designated as foreign terrorist organizations by the State Department. In some cases, membership in the Communist Party or other totalitarian political parties, although this ground has become less commonly used in recent decades. If you serve in the armed forces of a country that's hostile to the United States without permission from the U.S. government, this too can trigger scrutiny. Here's what makes this particularly complex. Even if you personally never engaged in violence, never committed any crimes, and never actually acted against American interests, the association alone can be sufficient to raise questions about your naturalization. The legal theory is that if you joined such an organization within 5 years of becoming a citizen, it suggests you may have had sympathies with that organization at the time of your naturalization, which means you may have lied during your citizenship interview when you swore allegiance to the United States and renounced allegiance to foreign powers. This opens the door for the government to argue that your naturalization was obtained through false pretenses, engaging in political activities on behalf of a foreign government that undermine American sovereignty or interests. These aren't merely theoretical concerns or questions for academic debate. These are actual legal criteria that the State Department and Department of Justice examine when determining whether someone's actions demonstrate an intent to relinquish citizenship. The burden of proof is on the government to show that you intended to give up your American citizenship. But certain actions create a presumption of intent that shifts the burden to you to prove you wanted to keep your citizenship. This creates a complex legal landscape for dual citizens who must carefully navigate their obligations and activities to avoid triggering a citizenship review. Now, let's discuss the most extreme scenario for citizenship loss: treason, rebellion, or serving as an agent of an enemy power. If you commit treason against the United States, engage in armed rebellion against the government, or act as an operative for an enemy nation during wartime, you can face not only serious criminal charges, but also potential citizenship revocation. These cases are extraordinarily rare in modern times, but the legal framework exists and has been used historically. We're talking about actions like providing classified information to enemy nations during wartime, taking up arms against the United States military, or actively working to undermine American security on behalf of a hostile foreign power. The loss of citizenship in these cases isn't automatic and isn't merely symbolic. It requires a full legal process that typically follows criminal conviction in federal court, complete with appeals and intense judicial scrutiny. The evidentiary standards are extremely high because the consequences are so severe. But the law is clear. If you're convicted of certain acts of treason or rebellion, citizenship revocation can be part of your punishment. This serves both as a practical consequence, stripping you of the legal protections and benefits of citizenship, and as a symbolic severing of your connection to the nation you betrayed. Here's something that most Americans have absolutely no idea about. Something that operates mostly behind the scenes without public awareness. The Department of Justice maintains an entire specialized section dedicated exclusively to denaturalization cases. This isn't some small side operation. We're talking about dedicated attorneys, investigators, analysts, and support staff whose full-time job is to identify potential citizenship fraud cases and prosecute them in federal court. This denaturalization section operates within the DOJ's Civil Division and works in close coordination with the Department of Homeland Security, Immigration and Customs Enforcement, and other federal agencies. How do they identify cases? They use a combination of traditional investigative techniques and cutting-edge technology. This includes cross-referencing biometric databases to identify individuals who may have applied for immigration benefits under multiple identities. They employ data analytics and artificial intelligence algorithms to audit millions of historical immigration records, looking for patterns, inconsistencies, or red flags that might indicate fraud. They investigate tips from the public, including from individuals in immigrant communities who may have information about fraud. They work with international partners and law enforcement agencies to identify individuals who may have concealed criminal histories or involvement in war crimes or terrorism. When historical records are digitized or when new information comes to light through investigations in other countries, it can suddenly expose fraud that occurred decades ago. When something suspicious is identified, investigators dig deeper. They interview witnesses, gather documents, review old files, and build a case. If they believe they have sufficient evidence to prove that citizenship was fraudulently obtained, a formal denaturalization case is filed in federal district court. At this point, you have every right to defend yourself. You have the right to hire an attorney. In fact, you absolutely should hire an experienced immigration attorney if you're facing denaturalization. You can present evidence, call witnesses, challenge the government's case, and make legal arguments. The government bears the burden of proving its case by clear and convincing evidence, which is a higher standard than the preponderance of evidence standard used in most civil cases, but lower than the beyond a reasonable doubt standard used in criminal cases. If the government successfully proves its case and the judge orders denaturalization, the consequences are immediate and severe. You lose your United States citizenship effective immediately. Your passport is revoked and must be surrendered. You lose your right to vote. You lose eligibility for federal benefits. Most critically, you lose your legal status to remain in the United States. You don't revert to being a green card holder. You become what immigration law calls a removable alien, which means you're subject to deportation. Depending on your individual circumstances and your country of origin, you may be deported quickly or the process may take time, but your legal right to remain in America is gone. For someone who may have lived in the United States for decades, who may have family here, who may have built an entire life here, this is absolutely devastating. What about people who were born in the United States? Are they vulnerable to losing citizenship? In almost all circumstances, no. The 14th Amendment to the Constitution provides extraordinarily strong protection for birthright citizenship. It states that all persons born in the United States and subject to its jurisdiction are citizens. This protection is about as ironclad as constitutional protections get. The government cannot simply decide to revoke the citizenship of someone born on American soil. However, there is one narrow exception, and it involves fraudulent birth records. If someone's U.S. birth was documented through completely fraudulent means, through fake hospital records, through false claims of parentage, through organized birth fraud schemes, the government can potentially challenge citizenship. These cases are incredibly rare and extremely difficult to prove because the government must demonstrate that the birth record itself is fraudulent, not merely that there were irregularities. We're talking about situations like organized fraud rings that produced fake birth certificates for children who were actually born abroad, or cases involving stolen identities of actual American-born children. The government has prosecuted cases involving birth tourism fraud operations and fraudulent midwife birth certificates along the Texas-Mexico border. But even in these cases, the legal and evidentiary hurdles are substantial, and courts are rightfully very cautious about stripping someone of birthright citizenship. So what fundamental principles tie all of these different scenarios together? 3 core concepts: intent, deception, and fraud. The United States government cannot arbitrarily strip citizenship away because officials don't like someone or disagree with their politics or simply feel like it. There must be clear, convincing, and provable evidence that fits into one of the legally recognized categories. Either you voluntarily chose to relinquish your citizenship through formal renunciation, or through actions that demonstrate intent to abandon citizenship, or you obtained citizenship illegally through fraud, misrepresentation, or concealment of material facts. The burden of proof on the government is substantial, as it should be given what's at stake, but once that burden is met, once the government clears that evidentiary bar in federal court, the results are final and completely irreversible. The implications of all this information go far beyond individual cases. This affects how we think about citizenship as a society, how we understand the relationship between individuals and their government, and how we balance competing interests of national security, immigration enforcement, and individual rights. For naturalized citizens, particularly those who may have made mistakes or misrepresented facts during their immigration process years or decades ago, this creates a permanent vulnerability for those currently going through the immigration process. It underscores the critical importance of absolute honesty and complete disclosure on every form, at every interview, in every interaction with immigration authorities. Even small lies or omissions can come back decades later to destroy your citizenship and your life in America. So here's the bottom line, and I want to make sure you understand this completely. United States citizenship represents one of the most powerful legal statuses available anywhere in the world. It comes with rights that are protected by one of the oldest continuously operating constitutional systems on Earth. It provides protections, opportunities, and privileges that literally millions of people across the globe desperately dream of obtaining. People risk their lives, leave everything they know, and endure tremendous hardship for the chance to become American citizens. If you hold U.S. citizenship, whether you were born with it or earned it through naturalization, you possess something genuinely extraordinary. But as we've explored in depth today, citizenship also comes with responsibilities, obligations, and yes, under certain circumstances, vulnerabilities. It's not an absolute unconditional status that can never be challenged or lost. The law provides specific pathways through which citizenship can be voluntarily relinquished or forcibly revoked. Understanding these pathways, understanding when and how citizenship can be at risk, is essential for every citizen and for everyone hoping to become one. If you're a naturalized citizen or aspiring to become one, the single most important piece of advice I can give you is this: be completely honest throughout the entire immigration process. Disclose everything required. Don't hide criminal history. Don't conceal marriages. Don't misrepresent your work history or travel history or anything else. The short-term benefit of hiding something is vastly outweighed by the long-term risk of denaturalization. If you made mistakes in the past, consult with an experienced immigration attorney about how to properly disclose and address those issues. If you're already a citizen and you're concerned about something in your past, speak with an attorney. Don't wait for the government to find it. For all citizens naturalized or born here, understand your rights, but also understand the law. Know what actions could potentially put your status at risk. If you're considering obtaining citizenship in another country, understand the implications. If you're thinking about working for a foreign government, understand the potential consequences. Knowledge is power, and in the context of citizenship, what you don't know really can cost you everything. This has been another deep dive into the complex world of American immigration and citizenship law here on U.S. Visa Updates. Our mission is to bring you accurate, detailed, thoroughly researched information about the policies, laws, and systems that literally shape millions of lives every single day. If you found this video valuable, if you learned something new, if this changed your understanding of citizenship in America, do me a favor. Hit that like button right now. Subscribe to the channel if you haven't already, and make sure to turn on notifications so you never miss an update. We cover everything from visa processes to citizenship issues to policy changes to breaking news in immigration. Share this video with anyone who needs to understand this information, whether they're citizens, green card holders, or on the path to citizenship. Drop a comment below with your thoughts, questions, experiences, or topics you'd like us to cover in future videos. I personally read every single comment, and your engagement helps determine what content we create next. Thank you so much for investing your time in watching this video today. Understanding your rights and the law is the first step toward protecting yourself and making informed decisions about your future. I'll see you in the next video where we'll continue exploring the complex, fascinating, and critically important world of American immigration. Until then, stay informed, stay engaged, and remember that knowledge is your most powerful tool. Take care.